Welcome to Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is episode 5, State of Missouri versus Marcellus Williams, part 1. We'll look at the 1998 murder of Felicia Gayle during a burglary committed by Marcellus Williams. In part 1, we'll talk about the murder and the investigation that led to Williams' arrest in 1999. Then we'll look at his trial, direct appeal, and post-conviction claims in state and federal court. And good morning, Kyle. How are you?
I'm doing well, Lisa. How are you?
Pretty good. It's Good Friday. Thank you for accommodating me sleeping a little late this morning.
No, absolutely. Well,
And also before we get into this, I do want to also thank Brad Hicks. If you all have seen the new cover art that we have for the avatars on our recordings and the YouTube and audio platform covers, those were done by Brad Hicks. I love them. They're really great. And I've been meaning to thank him for it on air. He's a former co-host on American Idiots podcast, which is where I got my start in. Okay, that's it. uh,
all right then.
all right, let's get started. The victim in this case is Felicia Ann Lisha Gale Pecos. She was born February 6, 1956 in Rockford, Winnebago County, Illinois. Her parents were George Wally Gale and Veronica Bunky Bunk Gale, who died in 2021. She had siblings William, Sanford, Andrew, Sydney, who's known as Beth, Samuel, who died in 2004, Emily, and Christopher. She was from a very large family. She attended Guilford High School and graduated around 1974, and then graduated in 1981 from the University of Illinois with a degree in journalism. And I believe there was another college stint. Either she went to one college and then transferred to the University of Illinois to graduate, but this case originating in 1998, internet information is a little bit sparse on both sides. She worked for the St. Louis Dispatch on the police beat from 1981 to 1992, and then she left that.
Sadly ironic.
Yeah, and apparently she got burnt out.
Apparently,
Uh,
what?
she was burnt out, and
Yeah.
so she left the St. Louis Dispatch, and went into social work. And so there may have been another college stint as well after she left. Her husband was Dr. Daniel Pecos. They were married September 21st, 1979. They were grew up together and fell in love and got married after college or while they were in college. Her injuries, cause of death, were multiple stab wounds. Then we have the perpetrator, Marcellus Scott Williams Sr., who took the name Khalifa ibn Rayford Daniels Abdul Qudus while he was in prison. He was born December 30th, 1968 in South Bend, St. Joseph County, Indiana. I don't know who his father was. There's no information, no name, nothing out there. I'm thinking the father's name was Rayford Daniels because in um, Arabic languages, Ibn usually means son of, I
Yeah.
believe. Could be
Well,
wrong on that.
it wouldn't be shocking if he didn't have a great relationship with his dad.
And his mother was Ella Louise Williams. He had three brothers. I don't have their names. Um, I didn't find anything indicating names for his brothers. in any of the records that I could find on him. He dropped out of the 10th grade in the second semester. He has a son, Marcellus Scott Williams Jr. He has been diagnosed with oppositional defiant disorder, depression, and post traumatic stress disorder. He had 7 arrests as a
What
juvenile,
is
and
oppositional defiance disorder? Does that just mean you're an asshole and we've given it a mental illness? I mean,
it's
we're making
yeah,
up new kinds
yeah,
of disorders to justify every type of bad behavior, it seems like.
right. It's something. I think it kind of started in the late '80s, early '90s, because I believe Chris Byers was also diagnosed as having oppositional defiant disorder. Um, so it's sometime in the early '90s. Yeah, it is kind of, but it's. I think it's seen almost like they have a compulsion.
Well, yeah, I mean, most criminals do.
But yeah, there are a lot of psychological diagnoses now that are uh, ADHD or he's got oppositional defiant disorder. And
That's
while
just
there's maybe some element of that, it still should not become a justification.
right. Well, yeah, I mean, yes, I mean, if you're a chronic criminal and a murderer, something is wrong with you.
Yeah,
But you're right. You said it well. It's like they sort of couch it as, oh, it's not really his fault because he has oppositional defiance disorder.
yeah. So he can't help himself. Um, and these were, I believe, post conviction diagnoses as well,
Of course.
which we probably will get into more in part two.
Well, yeah, and it
Uh,
sounds like he's just, he was just a jerk all around, both before he was in prison and after he was in prison.
yeah.
So he's definitely
So,
got a lot of disorders.
yeah. So his prior crimes, again, he had 7 juvenile arrests and he ended up in the Division of Youth Services at age 16. He had 16 adult convictions, including, but not necessarily limited to, second degree burglary, stealing over $150, and second degree assault in 1988. Second degree burglary and stealing over $150, 2 counts in 1991. First degree robbery, armed criminal action, unlawful use of a weapon, first degree robbery, armed criminal action, stealing a motor vehicle, and false imprisonment, also 2 counts in 2000.
So he
Um,
basically has I commit a lot of crimes disorder.
correct. And the false imprisonment were actually kidnapping, but
Yeah,
they were
that
reduced.
false imprisonment's kind of a nice way to say kidnapping.
Yeah. And he was incarcerated 7 years between 1990 and 1997. His disciplinary history, he had over 100 infractions, including verbal and physical altercations with inmates and corrections officers. And he threatened to kill a corrections officer in 1999 at the St. Louis City Workhouse. And his victim was Felicia Ann Lisha Gayle Picas, who was 42. Um, this crime occurred on August 11th, 1998. Victim was Lisha Gayle Picas. That was her married name. It occurred at 6946 Kingsbury in University City, Missouri, which is a suburb of St. Louis, in St. Louis County. And Lisha's husband, Daniel, was alive and practicing, from what I could tell. Um, and he remarried, but so he's still,
Still practicing.
yeah. So on the morning of August 11th, 1998, Lisha, oh, hang on a second. Pardon me, I'm sorry. My sister tried to come in the locked door. Okay, take two. I wish we still had Emily because she could have taken that whole thing out. Um, on the morning of August 11th, 1998, Lisha returned from her daily 2-mile run, stopped to share bananas and chat with her neighbors. After that, she returned to the home she shared with her husband, Dr. Daniel Pekas, an interventional radiologist at Barnes Jewish Hospital in St. Louis, to shower and change into her favorite long purple t-shirt. Williams drove his grandfather's Buick LeSabre to a bus stop in St. Louis and took a bus to University City, an upscale St. Louis suburb. Once there, he went to Ames Place, a gated community, looking for houses to rob. He picked the home shared by Lisha and her husband because the front entrance was partially obscured by a tree. When no one answered the door, he broke out a window, reached inside, unlocked the door, and entered the house. On the second floor, he heard water running. Instead of hurrying to grab valuables and get out of the house, Williams went downstairs to the kitchen, armed himself with a butcher knife, and lay in wait for his victim. Lisha finished her shower and put on her t-shirt and went downstairs. At the bottom of the stairs, she encountered Williams, who attacked. Lisha was stabbed 43 times in her back, thigh, neck, and had defensive wounds on her hands and arms. Williams left the butcher knife embedded in her neck. Before fleeing the house, Williams grabbed a jacket to cover his bloody shirt and stole Lisha's purse and her husband's laptop and case. He returned to the bus stop, rode the bus back to his grandfather's car, and picked up his girlfriend, Laura Asaro, a drug addict and prostitute.
So I mean, this is even. I mean, all of these cases are tragic, but he just wanted to kill her. I mean, he didn't need
Yeah,
to. He just wanted to.
yeah.
I mean,
He
it's
he
clearly. I mean, he could have robbed and gone, but he wanted to just be.
mhm.
Like I said earlier, he's got "I'm an asshole" disorder.
Yeah, there is absolutely no other explanation
Just yeah,
because
of pure hatred.
she was in the shower. He could have grabbed whatever valuables he saw, returned to the first floor, grabbed whatever valuables he saw could carry, and could have gotten out of there before she got out of the shower. But he
Right.
didn't. He armed himself
No.
and he waited there at the bottom of the stairs. And when she came downstairs, he attacked her and he brutally stabbed her. So, um, Asaro, when Williams removed the jacket, saw his bloody shirt and scratches on his neck. When she asked what happened, he told her he'd been in a fight. Later that day, Williams put his bloody clothes in a backpack and threw it down a sewer drain, saying he no longer wanted them. Asaro also saw a laptop computer in the car. That night, Dan discovered Lisha's body when he returned home at around 8 p.m. The University City Police began their investigation, but had nothing linking Williams to the crime, and he wasn't considered a suspect at that time. They had no conclusive evidence beyond a shoe print, fingerprints, and hairs that might identify a killer or might be unrelated. A day or two later, Williams sold the laptop to Glenn Roberts. The next day, when Asaro went to retrieve clothes from the trunk, Williams tried to push her away because he didn't want her looking in the trunk. He failed, and Asaro found Lisha's purse, looked inside, found her Missouri ID, and a black coin purse. Asaro demanded to know why Williams had another woman's purse, and Williams confessed to the murder. Williams told Asaro that he'd broke into the house, found the butcher knife in the kitchen, and waited for Lisha to get out of the shower. He told Asaro he'd stabbed Lisha in the arm, then covered her mouth and stabbed her in the neck and twisted the knife. Williams then grabbed Asaro around the throat and threatened to kill her, her children, and her mother if she told anyone about his confession. On August 31st, 1998, Williams was arrested on unrelated charges and incarcerated at the St. Louis City Workhouse. Asaro was arrested by the Vice Squad shortly after Williams's arrest on September 1st, 1998, and she told officers she had information about Lisha's murder. By the time detectives arrived to question her, she alternately expressed guilt for trying to use the homicide to get herself out of trouble or denied having any knowledge about the case. In April of 1999, Henry Cole was assigned to Williams's room. On an evening in May, a news report about Lish's murder was shown. Lish's family was offering a $10,000 reward for information leading to the arrest and conviction of her killer. Shortly after that report aired, Williams told Cole that he'd committed the murder. Over the next several weeks, Cole and Williams had several conversations about the murder, and Williams confessed. As he'd done with Asaro, Williams provided details about how he broke into the house and attacked Lisha. When Cole was released in June of 1999, he immediately went to University City Police and reported Williams' statements, which included information that had not been publicly reported. He also directed police to Asaro, who had not yet come forward. On November 17, 1999, University City Police interviewed Asaro, who told them what Williams had confessed to, or told him that Williams had confessed to killing Lisha. She also provided details that hadn't been publicly reported. The following day, a St. Louis Dispatch ruler and calculator belonging to Lisha were found during a search of the Buick LeSabre. The laptop computer was also recovered from Roberts, and it was identified as the one stolen from Lisha's home after her murder. Williams was still being held on unrelated charges when he was identified as Lisha's killer. On November 17, 1999, he was convicted after a bench trial of first-degree robbery, armed criminal action, unlawful use of a weapon, and remanded to the custody of the sheriff pending sentencing. On January 28, 2000, Williams was given concurrent sentences of 20 years each in the Missouri Department of Corrections on the robbery and armed criminal action convictions, and 7 years on the unlawful use of a weapon charge. All right, so these are, I'm going to kind of go over the two convictions that were concurrent to his being identified and tried for Lish's murder, because they all kind of swirled around in the Missouri courts at once. The first case was in the 22nd Judicial Court in St. Louis City. It was docket number 22-981-03157-01. The judge was Joan L. Moriarty, and she was in Division 23. He committed a robbery on August 31st, 1998. Robbery, armed criminal action, unlawful use of a weapon. He apparently robbed a donut shop and a Burger King in two separate robberies, but I don't know which one was the donut shop and which one was the Burger King, because the records didn't really reveal.
Yeah, it's honestly hard to keep track of all of his crimes. I mean, he's like an all-star criminal.
Yeah. And he was convicted after a bench trial on November 17, 1999, of robbery, first-degree, armed criminal action, unlawful use of a weapon. He was sentenced on January 7, 2000 to concurrent sentences, 20 years, and 7 years. And he filed a notice of appeal. The judge filed a description of the case with the Missouri Appellate Court, the Eastern District Appellate Court. They issued an opinion on February 6, 2001, essentially affirming his conviction. It's a very brief opinion, and they didn't find that a more detailed written opinion would have any precedential value. On March 19, 2001, his motion for rehearing or transfer to the Supreme Court were denied. On April 24th, his application directly to the Supreme Court was also denied, and the mandate issued on May 9th, 2001. He instituted a post-conviction action called a Rule 2915 action on August 2nd, 2001. Findings of fact and conclusions were issued by the court on June 4th, 2002. And he was denied relief on June 4th, 2002. He appealed that to the Missouri Court of Appeals in the Eastern District. And that was also a per curiam opinion, but it was a very brief one. And they made a finding that they affirmed, but made a finding an extended opinion would serve no jurisprudential purpose. And the mandate for that issued on May 1st, 2003. He was also indicted in the 21st Judicial Court for St. Louis County, docket number 21R00R-02972. That was presided over by Judge Emmett M. O'Brien in Division 11. He was indicted on July 13, 2000 for robbery, first degree, armed criminal action, kidnapping during facilitation of a felony, kidnapping during facilitation of a felony, 3 counts of kidnapping during facilitation of a felony, and stealing a motor vehicle. He went to a jury trial on April 2nd, 2001, and on April 4th, 2001 was convicted of all of the 3, the count 1, count 2, and count 6, but then counts 3 and 4 were amended to false imprisonment, and count 5 had been dismissed by the court, which was also a kidnapping. He was sentenced on May 25th, 2001. He was also given concurrent sentences, but he was to be served consecutive to the St. Louis City case number, 22-981-03-15701. So he got 10 years, 30 years on count 1, 25 on count 2, 1 each on 3 and 4, and 7 years on count 6, which was the stealing motor unlawful use of a motor vehicle. Those were consecutive to the St. Louis City case. So basically, he does his time on the St. Louis City case, and then the clock begins on his time for the St. Louis County case. And this would have effectively kept him in prison for the rest of his life, I believe. He filed a notice of appeal on June 11, 2001. He filed a pro se, or no, he filed it in the state court, the trial court, and then he filed another one in the appellate court on June 18, 2001. They issued another short opinion. They affirmed the conviction and did not go into any detail. On May 28, 2002, the motion for rehearing or transfer to Supreme Court was denied. The Supreme Court also denied a direct application on June 25, 2002. The mandate issued on July 11, 2002. He filed a motion for post-conviction relief on September 23, 2002. That was pro se. He requested additional time, which was granted on December 4th, 2002, to file an amended motion, which was done by counsel. That was filed on February 18, 2003. On July 22nd, 2003, and findings of fact and conclusions of law and order of the trial court, post-conviction relief was denied. That was appealed on August 28, 2003, and on April 20th, 2004, the Eastern District Appellate Court issued another brief per curiam opinion affirming denial and finding an extended opinion would have no precedential value. So now we go to this case. I just wanted to go over the chronology of that case because it was going on during the course of his trial in this case as well as after his conviction in this case.
Gotcha.
This was also in the 21st Judicial Circuit for County of St. Louis. Docket number was 2199R-05297-01. Initially, Honorable Stephen H. Goldman was assigned in Division 12, but it was then transferred to Honorable Emmett M. O'Brien in Division 11. And that may have been because he was handling another case against Williams, so they transferred him to the same division. Williams was represented by John Kramer, an assistant public defender. There was apparently later a conflict, and he was represented by Joseph L. Green and Christopher McGraw. The state was represented by Keith Scott Larner on January 6, 2000. Now, he was incarcerated in the St. Louis County Workhouse at the time he was identified as the suspect or killer. So he was arrested on those charges while he was being held in the workhouse. That arrest warrant was issued on January 6, 2000 and returned on March 2nd, 2000. And that may have just been that the paperwork was not filed immediately. He was indicted on January 6, 2000 on 5 charges: burglary first degree, murder first degree, armed criminal action, robbery first degree, and a second count of armed criminal action in count 5. He was arraigned on January 18, 2000. I'm presuming he pled not guilty, but it doesn't say in the record what his plea was. A notice of aggravating circumstances was filed by the state on February 4th, 2000. Cole and Asaro, who both feared Williams and were having second thoughts about participating in this process against him. Sorry, had to take a quick drink. On March 17, 2000, the state's request to compel Williams to give blood samples was granted over Williams's objection. On June 5th, 2000, Williams filed a motion to withdraw requests for detainers and waiver of speedy trial. On September 14, 2000, a notice was sent out setting the trial for June 4th, 2001 at 9 a.m. in Division 11. There had been a couple of prior trial settings, but those didn't go forward. Amended information was filed on February 15, 2001 in lieu of amending the indictment, but I don't know what the amended information was. The state again filed a notice of aggravating circumstances on March 7, 2001. A hearing was held on March 9, 2001 on the state's application to preserve testimony by video deposition for Cole and Asaro. On March 9, 2001, that request was granted, and the state was ordered to give proper notice of the depositions. Williams was going to be ordered to appear for the deposition by a writ of the court, and upon showing by the state of an imminent peril of death or additional circumstances that exist, the court might consider changing the time limitations. And I believe that they limited the time for the deposition. So you can only go 4 hours or 2 hours or 3 hours. But the court was willing to amend those limitations if the state proved that they needed more time for the depositions. Notices were issued on March 12, 2001, setting the depositions of Cole and Asaro. And then on March 15, 2001, by agreement, they set the depositions for March 12th for Cole and April 12th for Cole and April 24th for Asaro, and both of those would take place in Division 11 in the courthouse. The state filed 2 more aggravated motion to fingerprint Williams was granted, and the state also agreed that Cole and Asaro would be fingerprinted as well, because Williams was trying to claim that Cole and Asaro really committed the murders and are framing him.
That's probably about as good as his poetry.
On April 17, 2001, Williams' counsel filed multiple motions in limine. They filed multiple motions regarding death penalty procedures, death qualification of the jury, the jury instructions, how the prosecutor could deal with the jurors, what the prosecutor could say to the jurors. I mean, there were a whole host of motions challenging the Missouri death penalty. I'm sorry, my yard guy decided to come today. He also sought additional peremptory challenges. He sought to require the state to reveal any deal, agreement, or understanding with any potential prosecution witnesses or information about those witnesses. And is this getting too loud?
No, I don't hear anything.
Okay. He's like blowing right outside the window. Bless his heart. He filed to invoke the rule prior to voir dire, which would prohibit any witnesses from being in the courtroom or conversing, and to prohibit the prosecuting attorney from advising witnesses of previous testimony. He tried to filed a motion to quash the indictment due to unconstitutional discretion of prosecutor in seeking death penalty, for discovery of arrest and conviction reports of witnesses, to disclose confidential informants, for the court to pay for care of dependent children of family members and family members of single parents who were selected as jurors, or to not sequester the jury, to adjourn at a reasonable time, and to suppress evidence. So his attorneys filed a lot of motions. They did a lot of, and that means they did a lot of work, because most of those motions some are kind of boilerplate, but you have to supplement the boilerplate. On May 9th, 2001, Williams's motion to continue was denied. He was seeking a motion to continue because they wanted to do DNA testing. They were trying to link Cole and Asaro to the murder. And his motion to continue was denied. And again, this has been going on since 1999, so it's not like they just found evidence. Memorandum of notice was filed on May 18, 2001, by the state regarding potential use of Williams' statements made in December 1999 to January 2000 in the presence of Matthew Hose, a Mr. Davis, who was deceased, and a man named John Duncan. And that was all while incarcerated at the workhouse. Motion for actual conflict of interest was filed on May 23rd, 2001 by Williams pro se, and that was basically, he was complaining that his attorneys were not doing enough to impeach Cole and Asaro. Apparently, out in the free world, people were telling Williams's family all these things that they knew about Cole and Asaro, and Williams was trying to get his attorneys to follow up on those things, and they weren't doing it. But potentially because what they were being told was not going to be things that they could get into the trial, because it was inadmissible. So, and I can only infer that from later appeal opinion. Let's see. On May 25th, 2001, he was convicted for a first-degree robbery and armed criminal action. In another case, I think that's a mistake. Sorry. Because I found a reference to the conviction, but I didn't find the actual court record. Also on May 25th, 2001, an order was issued denying his motion to suppress evidence and his motion for continuance that he'd renewed. The trial was held in the Circuit Court of the County of St. Louis, 21st Judicial Circuit, docket number 2199R-05297-01, and that was with Judge Emmett M. O'Brien in Division 11. I should have removed Judge Goldman. Counsel for the state was Keith Scott Larner. Counsel for the accused were Joseph L. Green and Christopher McGraw. Findings of fact were issued on June 4, 2001, finding that Williams was a persistent offender under sections 558.016 of the Missouri Revised Statutes and section 558.021 of the same revised statutes. Jury selection went on from June 4th to June 8th, and the jury was sworn in on June 8th. The guilt-innocence phase of the trial lasted from June 8th to June 15th, and that made 14 trial days, including voir dire. The verdict was issued on June 15, 2001, and Williams was convicted on all 5 counts: burglary first degree, murder first degree, armed criminal action, robbery first degree, and armed criminal action. And I believe the armed criminal actions are armed criminal action for the murder and armed criminal action for the robbery. Because it's burglary when you break into a structure and steal from it, but it's robbery when there's a person present.
Right. Yeah.
In most statutes, that's the distinction.
Yeah.
And so the minute he went into the house, he committed a burglary.
Right.
And I think some people don't understand. They can charge you with everything you did.
Yeah.
They don't have to say, well, you just went into the house, but you didn't steal anything when you went into the house, so you get a pass on that one. No, that's not how it works. And it also doesn't matter if you steal $5 or $5,000. It doesn't change whether it's a felony or a misdemeanor, more, and it doesn't change it morally.
Right.
Judgment was entered on June 15, 2001, for the jury's verdict. The penalty phase was held June 16, 2001 to June 19, 2001. A motion for a directed sentence of life was denied. And the aggravators pursued by the state, and this is really interesting because there were 10. Whether the murder involved depravity of mind, whether the murder was committed during a burglary, whether murder was committed during a robbery, whether Williams murdered Lisha in order to receive money or something of value from her, whether the murder was committed in order to prevent the lawful arrest of Williams, whether Williams was convicted of second-degree assault on April 13, 1998, whether Williams was convicted of first-degree robbery on January 28, 2000, whether Williams was convicted of armed criminal action on January 8, 2000, whether Williams was convicted of first-degree robbery on May 25, 2001, and whether the defendant was convicted of armed criminal action on May 25, 2001. So the verdict of the jury on the punishment phase on June 19, 2001 was death. On June 19, 2001, Williams was remanded to custody of Justice Services, and his sentencing was set for August 17, 2001 at 9 a.m. He was also granted an additional 10 days to file a motion for new trial. On July 2nd, 2001, the sentencing was continued to August 20th, 2001 at 9 a.m. On July 13, 2001, Williams filed a motion for judgment of acquittal, notwithstanding the jury verdict, or in the alternative, motion for a new trial. And I'm really disappointed that these Missouri records are not available online at this time.
Is that just because Missouri just hasn't spent the time to put them online?
Well, they haven't put the older records online.
Gotcha.
And this is one I would love to read. Because the evidence is just, and I would love to read his and his attorney's rationalization of how Asaro and Cole committed the murder. Because I don't believe the two of them ever even met. On August 20th, 2001, a hearing was set on August 27th, 2001 at 9 a.m. So I think everybody came in for the sentencing, and that was moved to August 27th. A hearing was held on August 27th, 2001 on Williams's motion to proceed in form of pauperous, which I think in Missouri, I think you have to, at each stage, prove that you can't afford counsel and be granted permission by the court to proceed with public defenders or state paid counsel. And then the motion for judgment of acquittal was heard. They were also both denied for the motion for judgment of acquittal and new trial. He was sentenced on August 27, 2001 to 30 years on count 1, death on count 2, 30 years on count 3, life on count 4, and another 30 years on count 5. And it doesn't indicate whether they're consecutive or concurrent, and whether they're consecutive to the other two convictions. Notice of appeal was filed on August 31st, 2001 by Williams. An order was issued allowing Attorney Green to withdraw on September 17, 2001, and the Judge O'Brien sent a report of trial to the Missouri Supreme Court on September 25th, 2001. His direct appeal, because it's a death penalty case, proceeded in the Supreme Court of Missouri, case number SC 83934. His counsel were Rosemary Ellen McGonigal Percival, Kent E. Gibson, and Lawrence E. Comp. And they pretty much represented Williams throughout the course of his post-conviction as well. The state was represented by Evan Buchheim. Michael Spillane was the primary attorney, but Andrew James and Jeremiah Nixon were also on some of the pleadings and listed as counsel on some of the dockets. A notice of appeal was filed on September 10th, 2001. That was probably in the trial court. That was in the appellate court. The record on appeal was received on February 15th, 2001. Williams filed a motion to supplement the record on February 25th, 2002, which was granted on February 27th, 2002. The supplemental record was received the same day. I don't know whether the court sent the record and then they filed the motion and the order was granted supplementing it, or whether it was a matter of a transfer that only took a day. And I don't think there was any electronic filing at that time. So the appellant's brief was filed on June 27, 2002, and Williams raised the following issues on appeal. He challenged evidentiary rulings, claiming the trial court erred by refusing to allow defense counsel to elicit Robert's hearsay testimony that Williams told him he was selling the laptop computer on behalf of Laura Asaro, violating the rule of completeness, taking the transaction out of context, and allowing the jury to draw the inference that he obtained the computer by committing the charged crime or crimes. The trial court, he also claimed the trial court abused its discretion by overruling his objection to evidence regarding his attempt to escape from the St. Louis City workhouse. The trial court erred in failing to sustain his motion to suppress evidence of the post-dispatch ruler and a calculator seized during a warrantless search of the Buick he was driving on the day of the murder. The trial court erred by allowing the state to elicit excessive victim impact evidence, and that the state's evidence of other crimes constituted victim impact evidence from other crimes in violation of Section 565.030.4. He also challenged voir dire, that the trial court erred by allowing the prosecutor to employ the three-door analogy to explain to the veneer the assessment of punishment in a capital murder case, which was really um, a very interesting analogy. The trial court erred in overriding his Batson challenge to the state's peremptory strike of 3 African American veneer persons. He challenged jury instructions, claiming the trial court erred by failing to submit a written instruction regarding juror note taking, that the trial court erred in refusing to submit an instruction containing the section 565.031.3 section 4 statutory mitigator that Williams was an accomplice in the murder or played only a minor role in the crime, and that the trial court erred in overriding his objection and submitting to the jury an instruction listing 10 statutory aggravating circumstances. He also raised issues regarding closing argument, claiming that the trial court erred in not intervening sua sponte to prevent the state from improperly personalizing the case by asking jurors to imagine the fear Laura Asaro must have felt as Williams choked her and told her not to tell anyone that he had confessed to the murder, and that the trial court erred in overruling his objection to the state's penalty phase closing argument, in which the prosecutor argued that Williams was the judge, jury, and executioner. A supplemental transcript was received on September 9, 2002. The respondent's brief was also filed on that date. Williams filed a reply brief on September 25th, 2002. And on January 14, 2003, the Supreme Court of Missouri issued its opinion, which was reported at 97 Southwest 3rd, 462. The Missouri court found that because the state did not introduce into evidence any statements or confessions Williams made to Roberts during the sale of the laptop, the rule of completeness does not apply. Additionally, Williams was not precluded from showing that Laura Asaro once had possession of the laptop. He introduced testimony from 2 witnesses who said they saw Laura with a laptop computer during the summer of 1998. The trial court did not abuse its discretion in sustaining the state's objection to Roberts' hearsay testimony. Number 2, evidence of escape is admissible as bearing on defendant's consciousness of guilt as to pending charges. Such evidence is admissible even though the escape attempt may constitute a separate uncharged crime. Escape evidence is also admissible when the defendant is being held on multiple charges at the time of the escape. The existence of circumstances indicating the escape was not motivated by consciousness of guilt may be considered by the jury to reduce the weight of the escape evidence, but it does not render the escape evidence inadmissible. Whether the escape was motivated by a consciousness of guilt or another reason is a question for the jury. The evidence shows that the police, this is on the unwarrantless search. The evidence shows that the police went to Hill's residence, that's Williams' grandfather, and informed him that Williams was a suspect in a crime. The police asked Hill for permission to search the Buick, which was parked on a lot adjacent to Hill's residence. Hill stated that he was the owner of the vehicle and consented to the search. Based upon Hill's statement, the police had a reasonable basis to believe that Hill actually owned the vehicle, thus rendering the search valid. The trial court did not clearly err in denying Williams' motion. I'm not going to go through the victim impact evidence. Basically, they found that it is permissible and that, their jurisprudence as well as the Supreme Court jurisprudence hasn't rendered it inadmissible.
Gotcha.
And, that Williams didn't demonstrate manifest injustice because I believe he also did not object at the time of trial. So their basis for review is different when you don't object.
Right.
But it's kind of technical and it's not very
a little weedy.
Not very interesting.
Mm-hmm.
Now this is the Batson challenges because one of the things that the media tends to do is, portray claims that were made in direct appeal as being unresolved.
Yeah.
So this is how the Missouri Supreme Court resolved those claims. As to veneer person 64, they found that striking a prospective juror based upon clothing and attire does not reflect an inherent racial bias motivating the strike. The veneer person resembled Williams, had the same glasses, had a similar demeanor, and those were all reasons that are not inherently race based. And finally, they found that employment is a valid race neutral basis for striking a prospective juror who was a post office employee. They found veneer person 65. Even though the veneer person stated that he could consider the death penalty, the rationale given by the prosecutor was race neutral and supports a peremptory strike. They also found that the veneer person's criminal history is also race neutral basis for a peremptory strike because he had been court-martialed while in the military for stealing. So he may not have been qualified to serve on the jury.
Right.
And if he hadn't been struck and then he had gone on to sit on the jury and convict Williams, that would have been a grounds for Williams to say, "Ah, a felon was sitting on my jury. I get a new
Right.
trial," because that's what happened with Shayna Hubers.
Well, and if I can just make an aside, this is a point that people gloss over. I think it's funny when people always want to play the race card because there's more, black people in prison, but they never play the sex card. You never hear people saying that the justice system is sexist because more men are incarcerated than women.
Hmm.
And I feel like it's got to be both, right? Like, if you're going to claim the justice system is racist because there's a higher percentage of black people in prison, then you also have to believe that it's inherently sexist because there's more men in prison for committing crime.
Right, right. Um, well, yeah, but
It's a specious
women
argument.
are not really. It's more it's more sexist against women. And one of the things that I've said, the whole controversy over trans women competing and saying, not saying they're just women, they're not trans women. Well, not really. But if you really want to have an experience as a woman, you need to learn to sacrifice the things you care about and love and want for something else
Right.
or
I'm gonna
someone
put,
else. So you
yeah,
may have spent your whole life training as a swimmer, but if you decide that you're really a woman and you want to become a woman, you need to learn you got to sacrifice competing in swimming because you are not really biologically a woman.
right,
And the thing that aggravates me with this is that people are saying, "Oh, well, no man is going to become trans just to get into women's bathroom." Honey, predators will do whatever they can do. And
right,
when it became wrong to question a person about their identity, their gender identity, that's when predators started saying, "Hey, wow, I put on a dress. I say I'm a girl. I get to go in the ladies' rooms." And I'm also going to say this, and I know probably some listeners are going to get mad, but if a trans woman still has their original equipment, they have not had surgical alteration of their reproductive equipment, then they're not a woman. If you still have external reproductive equipment, you're not a woman. Period. You know, that's where we are. I mean, because there was a controversy in California about a trans woman being put into women's prisons, and he was impregnating and raping his fellow prisoners because he's not really trans. He's not really a
Right.
woman. He's just seeing an advantage because of the whole gender identity, the move towards we can't question people, and whatever you say goes. So if I say I'm a
Right.
cat, I'm a cat. And
Exactly.
sorry for that segue, but you started it with the sexist comment. Anyway, all right. So, um, and then finally, as to veneer person 72, the prosecutor struck veneer person 72 because he was fired from his job for physically attacking a fellow employee and because he appeared upset after other jurors laughed at him as he answered the prosecutor's questions concerning that incident, which are racially neutral explanations for the strike. They went on to say, although the trial court failed to provide the jury with a written instruction on note taking, the court did read that instruction to the jury. By reading the appropriate instruction, the trial court provided the jury with sufficient guidance regarding the proper role of note taking. The failure to include a written instruction, though technically erroneous, was not plain error. There was no miscarriage of justice, as the jury was read the proper instruction. And then they basically found that there was absolutely um, no basis for the accomplice instruction that Williams wanted. And again, I don't know what his story is. He's only an accomplice.
Yeah.
Because none of the argument or transcript or well, the transcripts are available, but I haven't really looked at them yet. So if I find any enlightenment on that reasoning for the jury instructions, I'll let everybody know in part two. There was evidence that several workmen had been in Lish's home in the month before the murder. Furthermore, Lish's husband testified that hundreds of guests had visited their home over the years and that the carpets had never been professionally cleaned. There was also testimony that people lose 100 or more hairs every day. The existence of several unidentified hairs thus shows nothing more than the coming and going of numerous visitors over the years. It does not show that someone else committed the crime or that Williams' participation was minor. Likewise, the unidentified shoe impressions do not support an accomplice instruction. Williams' expert testified that several shoe impressions, including some made in blood, were found near the body. The expert initially testified that the impressions were made by two different shoes. However, on cross examination, he conceded that the same shoe made all the impressions. Moreover, both Cole and Asaro testified that Williams told them he was alone when he killed Lisha. Evidence that one set of shoe impressions was found near the body does not support an instruction that Williams was an accomplice. And I think there's also the fact that if you don't have the shoes, you cannot say that that he didn't make the impressions. You can only say he didn't make the impressions if you actually compare the shoes. And I didn't find anything in the publicly available documents that show that the shoes he was wearing on the day of the murder were ever examined. They, for all we know, could have been in that backpack with the rest of his clothes, which was
Right.
never recovered because it was disposed of more than a year before he even became a suspect. So, finally, the testimony that Asaro was seen carrying a laptop computer does not show that Asaro was an accomplice. It shows only that she was carrying an unidentified laptop computer and is not sufficient to support an accomplice instruction. And then they went on to talk about the statutory aggravators at length. And they basically found that none of Williams' arguments about the aggravators were supported by the case law that he cited to. And they also found that the complained about prosecution closing was a fair rebuttal to Williams's argument for mercy during his counsel's closing. Um, and Williams failed to demonstrate prejudice. Then they did their independent review, and they concluded that the jury found 10 aggravating circumstances. However, as only one valid statutory aggravating circumstance is needed to consider imposition of the death penalty, we need not recite again the evidence supporting each one. So that's basically crimes in Missouri. And they've closed with saying that Williams confessed to the murder. The crime involved a vicious attack during a burglary. Williams has a lengthy and violent criminal record, and the sentence is not disproportionate. So the judgment was affirmed, and all concur, and there was no dissent. Williams filed a motion for rehearing on January 29, 2003. The motion for rehearing was denied on March 4th, 2003, and the court modified its opinion on its own motion, but it doesn't detail how it was modified. The mandate also issued on March 4th. Williams filed a petition for writ of certiorari to the U.S. Supreme Court under docket number 02-9792 on March 20th, 2003. That was his execution, which had been set for June 6, 2003, at the conclusion of his direct appeal, was stayed until further notice on March 24, 2003. And then on June 23, 2003, the U.S. Supreme Court denied his petition. And I also figured something out that I want to share with everybody because I was so excited when I finally figured this out.
What is this?
Okay. The year designation, it is based on the term of the court, not the year that everything is filed. Because I don't know if you've ever noticed, is that during the summer of 2025, things are still getting a 24 docket number. And that's because that is the 2024 term. The 2025 term begins in October. So that's when that term begins, that's when the docket switches to the next docket year.
Gotcha.
And, because I could never figure that out. And at one point I was looking for something and I was sure that I was looking for an order. And it was like, it had to be in this particular year because that's the year the petition was filed. And I didn't have the docket number for the petition. So I was just looking through orders for the guy's name. And that's when I realized, oh, wait a second. The year the way most courts do it.
Gotcha.
So, yeah, I just had to share that because
No problem.
I was so tickled when I found that. Okay, now we're gonna go. Now we're gonna go into the state post conviction. That was also in the Circuit Court of the County of St. Louis, 21st Judicial Circuit. That was docket number 2103 CC 02254, and that was also before Judge Emmett M. O'Brien in Division 11. Williams also filed pro se, but he was represented by Lois A. Hamilton and Robert W. Lunt in the state court post-conviction, and the state was still represented by Keith Larner, although I suspect that the Attorney General's office also did some work because that's generally how it works. Williams filed a pro se motion for post-conviction relief under Rule 29.15 on May 30th, 2003. He An order was issued on June 17, 2003, granting 30 additional days to file an amended motion, which was filed on September 8, 2003 by counsel on behalf of Williams. An evidentiary hearing was held on March 12, 2004. The matter was taken under submission. On March 12, 2004, the court also issued an order denying multiple motions filed on behalf of Williams seeking records regarding Asaro and or Cole. And apparently pre-trial, Williams filed motions to compel the prosecutor to provide them with these records, medical records, jail records, probation records, drug treatment records. And this will come into play during the post-conviction things. Motion for reconsideration was filed by Williams on April 27, 2004. On May 14, 2004, the court made findings of fact, conclusions of law, and issued an order, judgment, and decree. And they basically denied post-conviction relief and denied the motion for reconsideration on the denial of the motion seeking records. Then Williams filed a second motion for consideration on May 28th. That was also denied on June 10th. An amended order was entered on June 15th, striking affidavits attached to Williams' motion for reconsideration because the affidavits are not authorized by Rule 29.15, and the filing of the affidavits constitutes an improper attempt to expand the record with affidavits which are not subject to cross-examination. This is basically Williams and or his counsel went out and got affidavits from members of Asaro's family, extended family, Cole's family, extended family, talking about what horrible people they are. And how they lie all the time, and they're criminals, and she's a drug addict and a prostitute. She was also Williams's girlfriend, so he picked her. You know what I'm saying? He's got a lot of nerve claiming that, that makes her unworthy. And he also tried to allege that Cole was incompetent to testify based on some mental health allegations of like an incompetency in a criminal conviction of Cole or criminal action against Cole that was not really supported. On June 17, 2004, Williams filed a motion to vacate, reopen, correct, amend, or modify judgment. That was denied in an order entered on June 21st, 2004. Williams filed a notice of appeal. That appeal went to the Supreme Court of Missouri under case number SC 86095. Williams was represented by Melinda C. Pendergraph. The state was represented by Jeremiah Nixon, Evan Buchheim, and Deborah Daniels. Williams filed a notice of appeal in the appeals in the Supreme Court on July 6, 2004. His brief was filed on December 27, 2004. And he raised the following issues. On prosecutorial misconduct, he alleged that the state failed to disclose the addresses of Henry Cole and Laura Asaro, failed to disclose impeachment evidence regarding Cole and Asaro, and attempted to manufacture evidence against Williams. He alleged ineffective assistance of trial counsel for failure to investigate and impeach Cole, failure to investigate and impeach Asaro, failure to request a limiting instruction regarding his escape attempt, failure to introduce mitigation evidence, failure to file a motion to quash the indictment, and failure to advise Williams of his right to testify. He alleged ineffective assistance of appellate counsel on failure to raise on appeal overruling of a motion for continuance and failing to raise a claim that the trial court erred in precluding expert testimony. He also alleged claims regarding discovery under the Rule 29.15 proceeding that the motion court abused its discretion in overruling his motions to compel production of Assaro's drug treatment records, Cole and Assaro's mental health and corrections records, police reports regarding a separate murder investigation in Pagedale, Missouri, and the motion court's ruling saying the motion court's rulings prejudice his ability to advance his claim of prosecutorial misconduct. He also challenged the constitutionality of lethal injection. He alleged a conflict of interest, or he raised issues regarding the alleged conflict of interest for his trial counsel's failure to investigate impeachment of witnesses. And he alleged that he was rejecting his post-conviction counsel for failure to make detailed findings of fact and conclusions of law in ruling on the motion. And these are their descriptions. So I'm not quite sure what that one was, but hopefully when we get to the opinion, it'll be clear. Respondent's brief was filed March 21st, 2005. Williams filed a reply on April 8th. The case was argued and submitted on April 14th, 2005. The Supreme Court issued their opinion on June 21st, 2005, which was reported at 168 Southwest 3rd, 433. Their findings regarding Williams' prosecutorial misconduct claims were as follows. Williams' claims of prosecutorial misconduct were refuted by the record and did not warrant an evidentiary hearing. A review of the record and the motion court's findings on this issue reveals that the court did not clearly err in denying Williams' claims. The prosecution has no obligation to disclose evidence of which the defense is already aware and which the defense can acquire. During discovery in the Rule 2915 case, Williams filed extensive requests for production on the state that included Cole and Assaro's medical and psychiatric records from a variety of different federal, state, and private institutions. The state responded by allowing defense counsel to inspect and copy everything in the state's file on the case. If Williams' counsel wanted to acquire Cole and Assaro's medical and psychiatric records, the discovery request should have been directed at the entities holding those records. It is speculative and conclusory to allege that the prosecutor's offer of assistance to two men who did not testify at trial is tantamount to the manufacture of evidence that negatively impacts the credibility of witnesses who testified and were subject to cross-examination. The motion court did not err in denying this claim without an evidentiary hearing. As to the ineffective assistance of trial counsel, they found that the failure to investigate and impeach Cole, that any testimony regarding Cole's prior unrelated misconduct was not admissible to impeach his trial testimony. Trial counsel was not ineffective for declining to investigate and introduce inadmissible evidence. Williams' allegations regarding Cole's alleged mental illnesses are speculative conclusions, not facts, and the motion court properly dismissed this claim without an evidentiary hearing. As to the failure to investigate and impeach Assaro, as the motion court correctly found, this testimony that Assaro was a drug addict and prostitute and that she was framing Williams to receive a reward would have been cumulative to the evidence at trial because the record contained evidence of Assaro's drug addiction, prostitution, and that she might receive reward money for testifying at trial. Counsel will not be found ineffective for deciding not to introduce cumulative evidence. The motion court did not clearly err in denying an evidentiary hearing on this claim. The allegation that Williams and Assaro used public transit several times during August 1998 does not establish that Williams' car was inoperable on the date of the murder, and that Assaro was therefore lying when she testified that Williams gave her a ride on the day of the murder. The testimony also would have been cumulative because Williams' brother testified at trial that the car was inoperable. The motion court did not clearly err in denying an evidentiary hearing on this claim. The motion court did not clearly err in denying the claim without a hearing. The allegation that Assaro gave her mother some coupons does not establish that they were, in fact, the same coupons that had been in victim's purse. Absent a factual allegation that the coupons were obtained from Lisha, the allegation is conclusory and does not warrant an evidentiary hearing. They also found that the claim that Assaro's mother would have said she never got letters from Williams while he was in prison. The claim does not warrant an evidentiary hearing because it would not have impeached Assaro. Assaro testified, consistent with her mother's alleged potential testimony, that she was the only person who had read Williams' letter asking her not to talk about the Youth City incident. This testimony would not have provided Williams with a viable defense. The motion court did not clearly err in denying this claim without a hearing. There was also trial testimony that Assaro had access to the car trunk after Williams was incarcerated. Assaro admitted at trial that she had access to the car trunk to retrieve her clothing after Williams had been incarcerated. Williams' brother and cousin both testified that they saw Assaro use keys to access the car trunk. The motion court did not err in denying an evidentiary hearing on Williams' claims that counsel was ineffective for not eliciting this cumulative testimony. And I'm gonna skip over a few more of these things. Let's see. On ineffective assistance, they found that the appellate counsel was not ineffective for not raising the issue regarding the motion for continuance. Because at the hearing on the supplemental motion, defense counsel conceded that the state had no intention of using Hose's statement in its case. In fact, the state did not introduce at trial any evidence regarding Hose's statements. Williams could not have been prejudiced at trial by the state's decision to not admit Hose's testimony. Counsel also did not explain how forensic testing could establish that Williams was not present at the crime scene and that a continuance to collect this evidence was necessary for the defense. In any event, defense counsel presented trial testimony from two forensic experts who testified that none of Williams' hairs were found at the crime scene and that none of his DNA was found under the victim's fingernails. Williams' allegations do not support a finding of a reasonable probability that appellate counsel would have successfully argued that the trial court erred by not granting a continuance to allow for further forensic testing. And then, as far as the discovery, they found that the state opened its files to Williams' counsel and allowed counsel to freely inspect and copy any documents from the file. Many of the records requested, such as records from private drug treatment facilities and healthcare institutions, are not records that the prosecution had in its possession. The state is not required to obtain and then disclose records from other entities simply because the defense counsel makes the request. Defense counsel is free to pursue discovery from third parties on essentially the same terms as the state. They found probation and parole records are confidential, and that Williams made no showing that the Pagedale murder was in any way connected with the murder for which he was tried and convicted. Evidence that someone else committed the crime is not admissible unless there's evidence directly connecting some unidentified person with the crime. Or rather, some identifiable person with the crime. They found Williams' challenges to constitutional lethal injection had previously been rejected. The conflict of interest issue, they said the alleged conflict was that counsel was ineffective for not investigating impeachment witnesses. The motion contains no allegations as to how or why counsel was ineffective for failing to obtain a hearing on this issue. The motion court did not clearly err in overruling this claim without an evidentiary hearing. And then they found that when his claim was how the court handled the rejection of post-conviction counsel, and they found that the court did what it was supposed to do when he tried to reject his counsel. It wasn't required to make findings of fact. It held a hearing, and it elucidated its findings on the record, and that's all that's required. A motion for rehearing was filed on June 6, 2005. The mandate issued on August 30th, 2005, overruling Williams' motion for rehearing. And again, the opinion was modified on the court's own motion, but there's no detail as to how it was modified. Um, Williams filed pro se on October 17th, 2005, a motion for immediate release. I I would love to know what that was. I would love to read that one, but it's not available. And it was treated as a motion to recall the mandate, which was denied on November 22nd, 2005. And I think I am actually going to need to stop here because my throat is
That's a lot. I gotcha.
really getting
Mhm.
dry and it's harder and harder to talk.
Well, no worries. We can catch up next time.
So I think what we'll do is we'll pick up here with federal habeas in part two. And
All
then
right.
we'll
Well, that
go
sounds good.
on to because I don't think I can make it through about 10 more pages.
Mhm. No, sounds good.
Um, and I don't want to subject y'all to my voice getting worse and worse and worse. So, um, thank you for taking the time this morning. I know you wanted to start earlier, and because I'm
No, no
lazy, I
worries.
said no. Well, if we had started at 9, I would have had to essentially get up at the same time I get up every day to go to work.
So you could have gotten to sleep then. Fair enough.
And so I slept in. I got up at quarter to 9 and got my bath and got changed and then got my notes ready and got this ready for 10:30. I apologize again for all the background noise that we had with my
I did
sister
not hear
leaving the
it. I don't know if other
house.
people can. I did not hear
She tells me, "Oh, I'm going out the front door."
it.
And then she comes to the back door, which is still locked,
Is she older or younger?
younger.
Ah.
But she like she's just so bossy and mean sometimes. And it's like I don't know. Okay, my domestic implosion of my domestic situation is not anything that any listeners would be interested in. All right. So, thank you again, Kyle. I think we're going to call it on post conviction. So, his post conviction was denied in the state, and we'll move on to federal habeas in part two. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and you want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 3 weeks for episode 6, State of Missouri versus Marcellus Williams, part 2. In addition to talking about his federal habeas claims, we'll also look at Williams' subsequent state and federal post conviction claims, which led to a stay of his execution in 2017. Actually, 2015 and 2017. Then we'll talk about the 2024 efforts of the St. Louis County Prosecutor's Office to vacate Williams' murder conviction and that office's opposition to his execution on September 24th, 2025, including the DNA results that were falsely held out to exclude Williams as the perpetrator of Felicia's murder. Until then, have a great 3 weeks and stay safe.
Did I lose you?